In Minnesota, a 60911 offense is pretty serious. What that means is that law enforcement, you've been charged with the crime, but that when the prosecutors make the complaint, they'll often stamp a 60911 on it. And that means that they're seeking a mandatory minimum prison sentence because they're alleging that you possessed a dangerous weapon or a firearm in connection with whatever offense you allegedly committed. So things like felony drug possession or drug trafficking, as well as assaults in the first, second, or third degree, murder cases, drive-by shootings, and a host of other types of cases where they say it's much more serious even if you just possessed and didn't use a dangerous weapon or a firearm. It can work unjustly in circumstances. For example, let's say that you are a casual drug user, you've got a small amount of a user amount of a narcotic, for example, and law enforcement comes in and they find that drug, and then they look in your gun cabinet in your home where you keep your hunting rifle that you haven't used for 5 years but you like to hunt once in a while. Now they charge you with a 60911 and you're going to do a 3-year mandatory minimum if the prosecution gets their way on that case, even though you didn't keep that gun around to protect your drugs or any drug money. Rather, you just were a casual hunter and you happen to casually be using drugs. And that's not what the lawmakers meant to happen when they created these mandatory minimum sentences, but that's what can happen if you don't have an aggressive lawyer on your side that can bring a departure motion for the court. I just finished a case where we had a case where a person at home was a methamphetamine user, and this person had other people living with him that were also users, and law enforcement started to watch the house. They got a search warrant, they executed the warrant, and they found a whole host of different drugs as well, and these people were users, not really traffickers, but they also found 41 guns there because the person was a gun collector. And the client had no criminal history before, but the government stamped a 60911 on it and wanted the mandatory minimum 36 months in prison for our client. And I argued, if the guns weren't there, he would have been eligible for a stay of adjudication or maybe even de novo, where he wouldn't have had any drug conviction on his record because he had no priors. But the government said, we don't care, it's too dangerous when you have drugs and guns around. And that can be a dangerous situation. But if those guns aren't there to protect the drugs or the money, I don't think that really gets to what the legislature meant when they made these mandatory minimums. So we brought what's called a downward departure motion, and the judge granted it. And instead of he avoided going to prison for 36 months. So that was a good outcome, but you have to bring a downward departure motion. There are other cases where these mandatory minimum 60911s come in, things like an ineligible person in possession of a firearm. So if you've been already determined by a court not to be able to possess a firearm because you've got a prior felony conviction or a prior conviction for a violent offense, and then they find a gun on you later, you can be charged with a 60911, which is a 5-year mandatory minimum in those cases. There are other dangerous weapon convictions, for example, can get you a 1-year mandatory, a year and a day, or a felony conviction as a mandatory minimum. So the idea is, number one, were you really in possession of this weapon, or was it merely there and not within your knowledge or control, in which case you might not be in possession of the weapon and can avoid that mandatory minimum. Second, did you have a legal reason to possess the weapon for your own safety, for example, or were you under duress or necessity or other potential defenses? And third, even if all evidence points in favor of your guilt, is there something about the case that warrants a downward departure so that you can avoid going to prison or have a lot taken off of any term of prison that you're facing? So those are things that your lawyer should look at. Watch out for those 60911 cases. They get serious very fast. And most of the time, although the prosecution has a right to file the motion to agree that your sentence should come lower than the mandatory minimum, in reality they don't do it very often. A judge is free to do it even without the prosecution's agreement, as long as you don't have a prior 60911. But that still takes your lawyer knowing how to properly present a downward departure motion, and then how to advocate for that in order to convince a judge that you shouldn't get that harsh mandatory minimum penalty, and that takes a lot of work, both before getting to court on any sentencing hearing and then during the sentencing hearing, to make sure that we present enough mitigating evidence to the judge to warrant a downward durational or downward dispositional departure. If you have more questions about 609-11s or ineligible persons in possession of a firearm, my name is Ryan Pacyga, and you can find me at arrestedminnesota.com or at 612-339-5844.